Good evening. Thank you all for coming this evening. May I ask you to please take your seat? Again, thank you. I'd like to start this evening with some introductions. To my right, the Select Board, Christopher Ayer's Chair, Janice Livingston Vice Chair, and Sean Copeland's Clerk. Robert Montreal, not sitting there right now. He's down in the front row. Thank you. The Town Manager, Assistant Town Manager Carl Antonellis, and Mark Fish from KPL Law. That's our town attorney. So that's our clerk, Susan Copeland. May I ask you all stand for the pledge of allegiance? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you very much. I'm now going to ask Susan to read the return of the warrant.
Town of Ayer Special Town Meeting warrant, Ayer Shirley Regional High School Auditorium, 141 Washington Street, Ayer, Massachusetts, 01432, July 13, 2026 at 7 p.m. Commonwealth of Massachusetts, Middlesex, SS. Greetings. In the name of the Commonwealth of Massachusetts, you are hereby directed to notify and warn the inhabitants of the town of Ayer qualified to vote in town elections and affairs to meet in the auditorium of the Ayer Shirley Regional High School located at 141 Washington Street, Ayer, Massachusetts on Monday, the 13th day of July, 2026 at 7 o'clock in the evening, then and there to act on the following articles. Hereof fail not and make due return of this warrant with your doings thereof to the town clerk before the date appointed for said meeting. Given under our hands this 24th day of June, AD 2026, Christopher E. Tavares, Chair, Janice L. Livingston, Vice Chair, Sean C. Copeland, Clerk. A true copy attest, Susan E. Copeland, Town Clerk, dated June 25th, 2026. As directed in the foregoing warrant, I have this date posted 3 attested copies in 3 public places, one of which was the Town Hall at least 14 days before said meeting, all as herein directed. Samuel A. Goodwin, Jr. Constable, dated June 25th, 2026.
Thank you, Susan. And I should introduce myself. My name is Jeff Tillotson. I'm the moderator for the town of Ayer. I have a couple more comments before we start the meeting this evening. The Select Board is in session and recessed right now. The reason for that is they will, depending on the outcome of the meeting, have business to do. You're more than welcome to stay for the continuation of the Select Board meeting this evening after we dissolve this meeting. Other things. People who are admitted to the floor, registered voters of the town of Ayer, other individuals, including town department heads, town council, and other employees of the town who have business in today's warrant. Please sit in the 3 sections down front. That's the voting members of the floor. Non-voting members, please sit in the chairs along the back of the auditorium. Thank you. And finally, sorry? Oh, I thought you said something. No. And with that, Mr. Tavares.
Mr. Moderator?
Mr. Tavares.
I move that the town vote to authorize the Select Board to acquire by gift, purchase, eminent domain, permanent and/or temporary easement on property on or near Nonocotus Brook, West Main Street, Ayer, in the locations as approximately shown on the plan entitled Plan of Land Showing Proposed Easement Parcels Acquired in the Town of Ayer, dated May 5th, 2026. As said plan may be amended, and further to authorize the Select Board to grant an easement on town-owned property being Assessor's Map 26-31 for the purpose of accessing and maintaining a billboard for such consideration and on such terms and conditions as the Select Board deems to be in the best interest of the town. And further, to authorize the Select Board to enter into any and all agreements and take any and all actions necessary or appropriate to effectuate the foregoing purposes, all as written in the warrant.
Seconded.
So we have motion and second for Article 1. Any discussion? We have a presentation.
Good evening, town meeting. First, thank everybody for coming out. Nice night in July, but we're here for a very important project. I really appreciate that. Let me get this clicker working, right? So I have a brief presentation on the subject today. So West Main Street over Nonocoicus Brook Bridge project. So as everyone likely knows by now, the project, if you go down there, we have a single lane traffic light. It's in between Union Street and Rogers Street on West Main Street, and there's a picture of the old bridge. The project scope is to replace the existing stone bridge on West Main Street over the Nonocoicus Brook. That original bridge is thought to be built, estimated in the late 1800s. Approximately 8,000 vehicles per day travel on it, and it's in serious condition for Mass DOT inspections. And one thing to note is there's not a good detour route, so that's why we're doing the phased approach of construction and keeping a single lane alternating. Here's just a look at, fix this mic. Here's a look at the conditions of the bridge. And it's in very poor condition, stone masonry build, and also has railroad rails for decking. So we've been through many of this before. Go to the next. Okay, so current status. So right now, the single lane is set up for traffic, and they're working on the south side of the bridge, the contractor. They're currently working on utility bypass and temporary support for the bridge, so that they can get in there and take the old portion out in the south and put in a new portion. Next year, they would flip sides. So the issue at hand today is the town doesn't have legal access on an adjacent property, highlighted here in green, on the north side of the bridge. And I'll get into it more, but temporary access is needed as part of this bridge replacement. Permanent access would also be needed for future maintenance of the bridge. So town meeting approval is required to authorize the select board to obtain easements. Here is a view of the property that we are looking at acquiring easements on. And as you can tell, it's undeveloped. And you can almost see the brook down in there. It's higher above the vegetation. A little more information. You know, the property is predominantly wetlands. It has the river in there, the Nonocoicus Brook. And it's also undevelopable land per the assessor's card. One thing I should mention, we do have, I'd say, a litany of environmental permits we went through and obtained, so all the work we're doing is within accordance with those permits. So West Main Street over Nonocoicus Brook Bridge, these easements, temporary and permanent easements require town meeting authorization. Temporary easement, it's going to be needed for construction of the bridge, so it's a little bit wider than a permanent easement. Permanent easement's just needed for any future maintenance tasks as part of when the bridge is finally constructed. So the town's been working with the private property owner, and we proposed a license agreement in May 2026 as a temporary measure to gain legal access until fall town meeting, and fall town meeting's not until October. So we do use these license agreements, the town, frequently to provide immediate access and protections for the property owner and the town until we can have a town meeting. Most recently at our last town meeting, we had several with National Grid. And then we executed an easement subsequent to those license agreements. So the town did present the private property owner with the license agreement with significant legal protections, but the property owner is not amenable to the license agreement to serve as a temporary measure until fall town meeting. And so we're here tonight. Here's a look at the area we're seeking for a permanent and temporary easement. The green highlight is temporary easement. It's about 5,100 square feet. And the blue area is permanent easement, about 4,050 square feet. As we were going through this process and we were doing further due diligence, we did identify another issue, and it's the privately owned billboard. The privately owned billboard is partially located on town property, and access for installation and maintenance does require the private property owner to cross town property, so it's another thing we'd like to address as part of this. There's a picture of the billboard now. So why do we need this now? Why don't we wait till October? Well, 2026 construction phase impacts to the north side. Here's a list. We have water diversion installation and maintenance that needs to be done. Structural shoring of that existing bridge that's still in place that people are driving on top of. Maintenance of the erosion controls that have been installed. Monitoring and maintaining the existing bridge segment that's left in place. Any incidental access that might need to get into that side of the bridge for anything to inspect or maintain. General response as well, response to incidents. Could be an environmental incident, we could have a natural disaster or flooding. So it's really required for us to get in there for public safety. If we do not have access now, some of the issues that will come up, public safety concern, traffic on the existing bridge. You can see it on the picture on the right. This is kind of where people are traveling over right now. It's not in great condition, and we're monitoring it daily to see if conditions worsen. The project would be stalled if we don't have access now. We'd be unable to continue with our work on the south side. We could potentially miss our construction season this year, pushing our schedule and pushing a very important window. National Grid high pressure gas main can only be shut down a certain time of year, a couple times a year, for a short window, and we need to get in there for them to relocate their gas main on time. And then obviously costs would be a factor with delays. They come hand in hand. So what does this warrant article we're proposing do? It's pretty standard to our easement articles, but it authorizes the select board to acquire by gift, purchase, or eminent domain the needed temporary and permanent easements on the north side of the bridge. Emphasize easements. These are easements we're after to construct the bridge. Authorizes the select board to grant an easement on town-owned property for the purposes of the Sullivan Investment Trust bill work. Authorizes the select board to enter into any and all agreements and take any and all actions necessary or appropriate to effectuate foregoing purposes. And this is my last slide, but just reiterating the importance of access now and the public safety concerns which arise. Extending the traffic use of the serious condition bridge is not a good idea. We need to get and monitor and get the shoring in place, structural shoring, water diversion, maintenance of erosion controls, etc. Project delays and cost implications we mentioned as well as the high pressure gas main. And that's all I have. Appreciate your attention and coming to me. Thank you.
Thank you, Dan. Questions or discussion?
Mr. Moderator?
Yes, Mr. Torres.
I would like to make a comment that I think it's super important that this motion passes for these easements, mainly public safety. We saw the pictures of the bridge and how it's not in good condition at all. And any kind of delay is only going to stall this project, as Dan just spoke to. As well as the possibility that we lose access to the west end of the town if this stalls and something goes wrong where we have to close down the entire bridge. So I just wanted to lend my support to these motions.
Thank you, Mr. Morrison. Mr. Kern? Yes, thank you.
Dennis Kern, 51 Pleasant Street. On the face of it, again, I wasn't at any of the earlier meetings when this was discussed. On the face of it, this clearly seemed like an appropriate use that the town acquire the necessary easements in order to be able to, do the construction and have permanent access to that area. What I'm having trouble reconciling is the second paragraph where it is suggested or said that the town should grant an easement on town-owned property for the purposes of accessing and maintaining a private billboard, which evidently the Sullivan Investment Trust is using. Frankly, I think that particular billboard is remarkably unsightly. Secondly, it strikes me as rather odd that the town would want to grant access to a private property owner near a wetland for the purposes of maintaining a billboard I would suggest that we amend the article, remove the second paragraph, and then seek to acquire the permanent and/or temporary easements in order for the construction to continue.
Well said.
Mr. Moderator,
Mr. Hopkins.
Robert Conrad, Ayer Town Manager. Good evening. To address the second part of the article, the entire article tonight, we are looking to resolve an issue to the benefit of all parties. The first piece is we need the temporary and permanent easements, as the DPW director, I think, outlined very clearly. To Mr. Curran's question on the second piece, in the process of this, starting in April, it became evident to the town. We became aware that the billboard, a portion of it, is on town property. And furthermore, the only way you can access the billboard is to go across town property. Now, that is not meant as a criticism to the trust that owns it. But now that that issue is aware, we're looking to work collaboratively to fix that. Because right now, the property owner to erect the billboard or to maintain it is actually has to go across town property and would not have legal access. Sort of what the town has been identified as the issue without the easement. So through the moderator, that is the spirit of the article, and not to speak for the select board, but the intent of the board is not only to acquire the appropriate construction, temporary and permanent easements, but at the same time correct this legal issue as well. So that, again, Mr. Moderator, through you, not looking to debate Mr. Curran, but just to explain the reasoning behind the second part of the article.
Thank you. Mr. Curran?
Okay, yeah, I'll, if there's no one else yet. I understand your point, Robert. Again, it does not seem to me to be appropriate that the town be, that is, the town can seek to acquire the necessary permanent easements. It is in the long term, in my view, the long-term best interest of the town that we not grant to a private property owner access to town-owned property for the purposes of maintaining a private billboard, which presumably is providing profits to that private property owner. If it is in fact town-owned land, then the town should acquire it or do what's necessary to acquire it through eminent domain in order to give us the obvious necessary access for the construction. So, Mr. Moderator, I would like to make a motion to amend the article.
Do you have it in writing, sir?
I do not.
We will need it in writing, sir.
Would you, is there someone who will?
I believe the motion, as it's written, gives the latitude to the select board to make this type of negotiation. Okay? Then I don't know what the negotiations will include, Mr. Curran.
Mr. Moderator?
Yes.
If I may, Town Council?
Go ahead, Mr. Wrench.
Thank you. To the point, and I fully understand, Mr. Ryan, I fully understand your point. And for better or for worse, it's not uncommon in municipalities for private property owners to encroach on municipal property. You have so much property in the town that is owned but not necessarily intensively monitored by the town, so encroachments occur. This billboard has been in place for many, many years, I think, approximately 2 decades or more. And well, the issue, as town manager talked about, is we're not looking to start another fight. We're looking to try to resolve issues for the benefit of everyone on that site. The billboard footings encroach to a slight extent, a relatively minor extent, onto town-owned property. We understand that. We found that out during the process of reviewing the circumstances on the property. So certainly, if the town was going to take an aggressive approach, the town could have issued a cease and desist order, gone to court, forced the billboard to be removed. But the billboard's been there for a very long time, and the town's just simply not looking to do that. in regard to the first part of the article, obviously, it's a very necessary situation to gain access for construction and maintenance of the new bridge. So I think you're not debating that, so we don't need to discuss that at this moment. On the second piece, and I don't mean to say we're debating, again, I fully understand your position, but we know what our property is, they know what their property is, and we see this issue. We're trying to resolve it to the best we can, because if the town doesn't grant this easement, if by your motion the second paragraph is deleted, that doesn't mean that the billboard and its footing is going to be removed. The town would still have to, through the select board, determine whether to take an action against the property owner to force them to remove it. The status quo right now would be to leave it as it is. We would be then engaged in a legal effort to require that billboard to be removed. There's expense and efforts to the town. That would become an extensive discussion before a court seeking an appropriate judgment, and that would be a determination by the select board to even pursue that. The authority that you're being asked to grant right now, as the moderator himself mentioned, this is authorization. It would allow the select board to grant this easement. It doesn't require them to grant this easement. So the board, in the interest of town, will be weighing all these interests and determine what is the best course of action to protect the town. We're doing this, again, this is not being done in the interest of public resources being expended for private purposes. It's being done to avoid any suggestion that the town's taking retaliatory action by acquiring these. And so we're trying to resolve all the issues in this location, and we're trying to avoid what could be a somewhat messy circumstance if we don't resolve it on both sides. So again, to your point, select board has that authority whether to proceed or not, and would obviously be reviewing to make sure that anything that's done is in the best interest of the town, keeping in mind that it's undevelopable property, it's not property where you and I could go down there and take a walk and access it. It's a wetlands area, it's not usable. So the town's interest and the risk to the town of that use of its property for the footing of the billboard and for access to that footing by the trust, that's a significantly minimal impact to the town, and one that there seems to be a justification given the trade-offs presented in this article. So I hope that's helpful.
I disagree with most of it. Needless to say, what you describe as a minimal impact is in fact a 30-foot by 50-foot high billboard in a residential neighborhood encroaching on wetlands on town-owned property. Well, on town-owned property or encroaching upon town-owned property. Why it was ever allowed to be put there to begin with is certainly a question. But now that we have an opportunity and a justification for not granting them a temporary and or permanent easement which would perpetuate it, this is our opportunity not to perpetuate a historical wrong. I can't make it any clearer than that.
And I guess, again, Mr. Ryder, through you.
Yes, Mr. Ray.
And I apologize that I don't know engage, but I think it's important to answer that. I understand, and I'm not debating the positions you're taking, but keep in mind, we're not discussing whether the billboard is going to be taken down or not. That's not what's before us right now. So the only issue is that encroachment. So when you talk about the historical wrong, I can't answer for what happened 20-odd years ago. As much as I've been town council for the town of Ayer for that long, but I have no idea what resulted in this. And the issue that you talk about really would be one that would have to be resolved in a court of law. So I understand your point if you take issue with my saying it's the minimum impact. I'm not talking about the billboard itself. I'm talking about that area of encroachment. I can't debate you. I don't think anybody here, maybe someone would say that the billboard has an aesthetic impact, a positive impact. I think most of us probably don't agree with that. But putting that aside, that's not at all the issue that we have before us, because even if you took that paragraph out, it would not result in quote-unquote righting the wrong, it would simply maintain the status quo as it is, because the select board would have to determine whether to take, again, enforcement action to have that footing pulled back. It wouldn't necessarily result in the removal of the billboard itself, but it puts before the select board the same authorization essentially that's here. If the select board takes no action, the billboard remains and the footing remains. It's highly unlikely that we will be embarking on an effort to remove that footing simply because of the legal expense and the likelihood that even just pulling that footing back would maintain what we see there right now.
Excuse me, Mr. Kern. May I ask a question? For a practical matter, we're trying to get the road repaired as soon as possible. Would that extend the time and make it more difficult for us? I'm asking for an opinion, sir.
Thank you. No, thank you, Mr. Hart.
And the practical matter is this is to give the select board permission to negotiate on our behalf to move this forward.
I think, Mr. Moderator, you're raising a very good point, because one of the reasons that this came up and the reason it's in the warrant article itself, as determined by the DPW director, the town manager, and ultimately the select board, is to inject, as to the maximum extent possible, fairness in this process to minimize what may be a legal challenge in the future based upon how the property is acquired, based upon what happens to that footing. So it's our position that this provides a fair and appropriate mechanism to address the needs of the town right now without forcing the town into a fight and without opening up an argument about the treatment and retaliatory treatment, which I think we could deal with. But I think this gives appropriate authorization, and removing that provision would not, in my opinion, change the circumstances, would not result in righting or wrong. And again, I understand the position. I'm not debating it at all. I fully understand, and I didn't mean to minimize the impact of the billboard. I'm just talking about this area of the footing, which is really a lesser impact than the billboard itself. So I don't know how long you want to.
Thank you. So to be honest with you, we have a motion for an amendment on the floor.
Was it seconded?
We haven't had a second. We've been discussing it. I apologize for that. Do we have a second for Mr. Kern's motion? Motion.
We have to have a written motion.
Not in writing.
Could someone give me a piece of paper so I can, and essentially it's going to be remove paragraph 2.
I think that's understood.
So the full deletion of paragraph 2. Do we have a second?
Second.
Move to second. Do we have discussion on the amendment?
Behind me an opportunity. Let me just say that.
I believe you've made your point twice now.
Well, this is the new amendment. This is the new article based on the change.
We're only talking about, Mr. Moderator, we're only talking about the amendment at this point.
Yes, we can only discuss the amendment at this point. Yes.
So, it would seem to me that approving this article with what's up there with paragraph 2 removed gives to the town the ability to acquire what's necessary to continue with the construction. If at a later date, the town will have time to properly vet all the circumstances around whether or not an easement should be granted for the footings of the billboard. That can be deferred to a later date. Articles 1 and 3 will now, paragraphs 1 and 3 will now allow us to proceed.
Mr. Moderator, just as a follow-up comment, and again, I'm not looking to debate, but this has been fully vetted. The town fully understands the circumstances. This is what came up during the review of the process. So, if you want to talk about the proper timing, the timing is now rather than deferring the same matter to another town meeting. So Mr. Moderator, I don't know if you want to hear from other.
So view of proper vetting is an emergency town meeting called for the second Tuesday in July.
I'm sorry, Mr. Kern. Yes, please. I'm sorry, I can't see who you are from back there.
I'm Jane Moore.
DJ, come over to this microphone. I'm sorry. Is this to the amendment, sir?
Yeah.
Over there was a...
I'm sorry. It's difficult for me to see.
She was first.
I understand that. Over here. You're speaking to the amendment, Ruth.
Ruth Matson, Show 17 Taft Street. I wanted to speak about the original acquisition, or you want to speak about the...
About the amendment. So can I ask you please to be patient?
Pardon?
Can I ask you to be patient? We're going to discuss the amendment right now that Mr. Carr just put on the floor.
No, I didn't want to speak about the amendment.
So may I ask you to be patient, please? We're going to talk about the amendment right now.
Okay.
Okay?
Yes.
Just, like I said, gentlemen, are you here to speak about the amendment?
I believe so, yes.
Please identify yourself. And
You can tell me after I ask my question. Luke Ennis, 19 William Street. Curious if the select board or anyone from the town can provide us any insight into the financial considerations behind the acquiring of these easements and whether granting the mapping easement for the landowner to access their billboard is lessening the financial burden that the town is going to take on in this particular motion.
Mr. Moderator, yes, before turning this, I will point out there's no financial consideration being proposed in this warrant article. Right now, there's no money on the table on either side. Whether that's resolved through project funds would be determined as the process moves forward. Right now, before town meeting, there's no funding, no taxpayer dollars involved.
Yeah.
The only way we can have taxpayer dollars involved would be to appropriate those funds at town meeting, and we're not. That's not in this article, so there's no appropriation.
Yeah, I understand that, but it sounds like the property owner is not terribly on board with what we're trying to do, so I'm curious if we are trying to be nice to them so that the potential tax. I know that's the case, I just would like.
I think that's, obviously there's what, as I said already, through you, Mr. Moderator, as I said already, the intent is to mitigate on both sides to make this a fair process for both sides. So I think, to your point, it would be our hope that this would lessen any debate or dispute over the acquisitions by being fair. So it's being considered to the benefit of the town. Obviously, again, this is authorization of the select board. It's not obligating the select board to take any of these actions. So the select board will weigh that based upon what discussions happen after the town meeting votes and how to proceed appropriately. And obviously, the select board is going to act in the best interests of the town. So I think to your point, there are benefits to having this authorization because it allows a bit more of a negotiated resolution as opposed to almost a less amicable resolution. I hope that helps.
Yeah, more or less. Thank you.
It's all yours.
Excuse me, Jane? Excuse me, Jane?
Yeah.
I'm going to alternate. Are you speaking to the amendment, sir?
I believe so, yes. Avenue Carrier, 57 Cambridge Street.
Thank you.
And I hope this won't sound either impertinent or ignorant, but are Articles 1 and 2 connected in that the same landowner is being dealt with? Because that is not clear to me from the language of the article.
So if I may, this is one article. There are multiple pieces of one article. Everything we're dealing with is the same property owner, yes.
Okay, very, very good then. And if I may ask a follow-up question, has this sort of, at the risk of using legal language incorrectly in front of a lawyer, is this quid pro quo been kind of run by the property owner, and if they've been, it's great to be nice to people, but being nice when you haven't talked about the other person being nice to you is often the way to be taken advantage of, and that's my concern.
I think it was a very good point, sir. Through you, Mr. Moderator. And the town obviously wants to work with any property owner within the town within certain bounds. And so the point of getting this authorization is to allow the select board to work as much as it can. As you have heard in the presentation, initially we presented a license agreement which would allow for essentially a stopgap measure between now and the fall town meeting, which would have allowed more discussion. That was not met with favor. So we're at this point where we're trying to accomplish something that we have to accomplish. The second part that we've been debating under this amendment is intended to give the select board as much authority, as many tools in the toolbox to resolve this. We certainly try to be nice, but we also know what we need to accomplish. At the end of the day, with town meeting's approval, We need to accomplish this bridge project. And we will do, instead of the town select board, the town manager, the director of public works, will do whatever it takes to protect public health and safety. And you all saw the condition of that bridge with those simple photographs. It's a problem that has to be resolved.
Thank you, Mr. Rich. Jane.
Jane Morris, 62 Pleasant Street, Ayer, Massachusetts. I have a question. Is this adverse possession, the billboard?
So,
does it fall under that?
Through you, Mr. Ayer, adverse possession doesn't apply to town property. That's a private property concept. So if you encroach on town property and you hold it for 20 years and you build on it, that doesn't mean you obtain it by adverse possession. The law is very clear on that. Again, it gets back to my point earlier. We as the town can't monitor every square inch of our property. It's protected very differently. If I have a house next to yours and I extend my backyard onto your property and you know about it and I maintain it for 20 years, I may get property interest on your property. That's adverse possession or prescriptive easement, different processes. That doesn't apply here.
Thank you.
Thank you.
Thank you. Over here, please. You bought it.
Paula Sullivan, 191 Groton Road.
Thank you.
Please.
You can hold it.
I can?
You can hold it.
Okay, might be easier.
That's better.
Sure.
My brother and I and my sister are the property owners, just for clarification. This all started way back months ago. And our basic question always was, my brothers and mine and my sisters, why were we never notified from the get-go? And the only assumption we can make is when you went back to look at maybe who owns the property. It used to be my dad's, it was in the family forever. He passed away and it went to my mom. And at one point in time, we tried to give the land away. The town didn't want it. We've had, don't ask me when, since I've been little, but that billboard has been in our family since like 1981, something like that. It might not be aesthetically pleasing, I don't know. And we get a pittance, nobody's getting rich off the billboard. But my thing is if you resolved the other side of the bridge, how come, you must have looked at some point and said, who pays the taxes on this land? Or if you asked the billboard company who owned it, wouldn't they have given you our name, who would have been notified?
If I may, Mr. Moderator.
Please, Mr. Rich.
I think, again, what happened on the south side, yeah, there was an extensive need for work on that side. I think in looking at the north side, there was a sense that it could be accommodated otherwise. Unfortunately, as you know, based upon some contractor use of your own property, which we did have to address, we determined that we would be encroaching. And once that determination was made, and it's unfortunate that there was an earlier notice, but once it was determined in the past few months, the town sprung into action to try to resolve this.
It was, excuse me, it wasn't unfortunate. It was, if somebody had done their due diligence, they would have known that someone owned it, somebody was paying the taxes, and you took care of the other side, and you started to come over. If we didn't come down one day, my brother happened to come down and walk where my Aunt Molly, where the property was, and saw that stuff was going on. I don't travel that into town all the time. Our big thing was, what if a contractor had fallen, or you hear the things in the news all the time, like, contractors fall, staging, or we didn't want to be liable.
And if I may, Mr. Moderator,
We're actually getting a little away from the
we are, but I say,
please.
I'll try to keep an arrow. I apologize. I know you all are so enjoying listening to me talk, but I'll try to bring it back a little bit. The reality is, if something happens to the contractors, under our own contract, they carry extensive insurance. We monitor that. We also have insurance through the town. We would maintain that liability. And I understand the point. And to be honest, that's why we offered in the license agreement indemnification and insurance, because we were sensitive to that. But that was rejected. So we are aware of that, and that's why we're here today. Whether it was done when the south side was addressed, or whether it's being done now, it addresses the same issue. And we would have been here at the same time as the south side, but now we're here to deal with the north side. So I think at this point, the timing of the issue and why we're here now, that's not really relevant to the fact that we're here now.
Well, if I could say the town was encroaching on our property, because all this stuff was there before we even were notified.
And you're encroaching on the town's property and resulting in this.
Excuse me for a moment. I'm going to ask you not to argue in a public forum, please.
And it's
Yes, and I want to bring it back to the, I'm sorry?
my understanding is there's only one leg of the sign that's on town property.
It's still in.
Thank you. I believe that was part of the presentation.
Thank you, Mr. Moderator.
On this side, Mr. Dixon?
Ken Diskin, 180 Washington Street. So I'm here to talk against the amendment and get back to the discussion of the amendment so we can vote on the amendment. But it's clear to me, I think, and it should be clear to everyone, that to call for a special town meeting on a subject like this date, we have had a good discussion already in the town hall. I believe strongly in the DPW's initiative here. I believe the town manager and the select board have reviewed it. I think if anyone wants to discuss the matter of changing this while it's before the select board, they could attend those meetings and submit their thoughts at those times and let the select board go through the process of authorizing it and determine during the meetings with the select board if they want to tweak the evidence of the language of this article. But I'm against the amendment. I want to let the article go through and move on and let the select board have the authority to go through these easements, write the final language with the town council, and any debate or any discussion can happen at those select board meetings. Thank you.
Thank you, sir.
Gentlemen, here, do you have a comment on the amendment?
Yes, my name is Hans Schluter, 44 Pleasant Street. As far as I'm concerned, private property is part of private property. You don't just take it, okay? So I'm all keeping the second part of the paragraph in.
Thank you. Other comment over here on the amendment, please?
Yep, Jessica Gino, 8 Mountain View Avenue. It seems that number 2 is just incidental. It's part of the bargaining process that the select board could use. I don't think we should be doing negotiating over the history of this property here. And I think we should just move on with what do people feel about the motion to exclude number 2. I say move the question. I would
Unfortunately, you can just stand up and say move the question. You can't argue and then say move the question. But thank you. Ruth, do you have something on the amendment?
No, not technical amendment.
Not the amendment? Okay. See, no more comments on the amendment. I believe it's a simple majority?
Yes, sir.
Simple majority. All in favor of the amendment, please say aye. Aye. Opposed? No. The amendment does not carry. We're back to the original motion. Ruth, you have a comment for the original motion, please.
Ruth Madison, 17 Taft Street. I was a little bit taken aback when I saw that the homeowner or landowner had not been approached until May, it sounded like. We've known about this project. And why wasn't this land taking or proposed land taking talked about long before with the homeowner or landowner, I should say? And why is it presented to, and we have to go through all this because it wasn't done nicely, genteelly, I would say.
Mr. Moderator.
Mr. Rich, yes, please.
I think already you've indicated a lack of interest in going over the timing of the issue, since that's not what's before us. But just to reiterate, the same issue arises in discovering the encroachment on the town's property. This is something that was discovered, it has to be addressed. To suggest that it wasn't done genteelly, it's been done as gently as we possibly can, which brings us to tonight. We would have liked to have resolved it again through a cooperative license agreement. That didn't happen. Whether it happened, whether the south side was addressed or not, here we are. So I think the timing of the thing, that's really not an issue at this point. If town meeting is not happy about the timing and votes down, so be it. But I don't think that's something that we could address tonight.
Well, I don't think this happened too short a time. The landowner should have contacted them well over a year ago on that. There's no reason why you shouldn't have been aware of this. And why was it done too short a time?
I don't think there's a good answer for that.
Yeah, I don't think there's an answer to that. It was missed along the way. Thank you. Jeff, is it? Again, lights, I can't see people very well.
Jeff, 72 Pleasant Street. Looks like all Pleasant Street people are out tonight. My question is since the license agreement didn't work, and there's a host of other mechanisms that are listed in the article, and we exhaust all of them, and then it comes to eminent domain, do we not all have to come back here again anyway to vote on the money for the eminent domain?
Mr. Moderator, no, we luckily we don't have to do that. We're not asking for you for any money because we have project funds we would look to. So that will be addressed, and so we would not have to come back.
Thank you. It looks like the lines are gone at the microphones. Any other further discussion? Hearing none, with simple majority. All in favor of Article 1, please say aye. Aye. Opposed? No. Article 1 passes. I will remind you before we dissolve that the Select Board will now go back into session to work on this. It's a public meeting. You're more than welcome to stay here.
Do we need a motion to dissolve?
I need a motion to dissolve. From somebody?
Mr. Moderator, I move to dissolve the special town meeting.
Second.
Thank you. Moved and seconded. To dissolve the meeting, all in favor, please say aye. Aye. Opposed? Thank you very much for coming out this evening.